The Speaker, Honorable Amason Kingi, has directed the Sergeant-at-Arms to rally the members of the Kisii County Assembly to make their way back into the chamber to necessitate the commencement of the closing statements on behalf of the County Assembly, which has been allocated 60 minutes, as well as the closing statements on behalf of the Deputy Governor, allocated another 1 hour before the senators decide on the 4 grounds for impeachment that embattled Kisii Deputy Governor is currently facing. And our dear viewers, just to mention to you, some of the grounds for removal are matters to do with abuse of office, where the governor is facing allegations of receiving 800,000 shillings bribery to lobby for a job for a son of a personal friend of his. The governor was also impeached on grounds of gross misconduct. In this particular charge, the governor has been accused of bribing the managing director, Ms. Lucy Wahito Wachira, a sum of 100,000 shillings in May 2023, in contravention with Article 75 of the Constitution of Kenya. According to the members of the County Assembly, the Deputy Governor's engagement convenance as well as did complicate behavior, and this boils down to gross misconduct and abuse of office. The 4th ground for impeachment, which the Deputy Governor for Kisii County faces this evening, is the crimes under the national law. In their submissions in regards to this particular case, MCA said the soliciting of bribery is matters to do with crimes under the national law.
You approximately need about 30 minutes, but you're not lost of the fact that 1 hour is still available to us. Mr. Speaker, sir, with your kind permission, kindly allow me to invite Mr. Mutuma to do an opening remarks, and then I and my learned friend, Mr. Mwangi Ndegwa, shall share the balance of the times.
Thank you, Mr. Speaker, sir. I will do the introductory remarks, then yield to my friend, Mr. Mwangi, to take you through the evidence that has been produced in this court. I will begin by looking at a scenario of one gentleman called Abdulaziz Ishan. Abdulaziz Ishan is a property developer who was accused of forcing himself on an 18-year-old girl and was charged in court, the Southwark Crown Court. In his defense, he said that I fell and penetrated her by accident. Now that defense, honorable senators, shocked the world, that he fell and penetrated the girl by accident. It was an obvious lie. It was a lie that everyone would see was a lie. Surprisingly, Mr. Abdulaziz got away with it based on that lie, insulting the intelligence of the very men who are listening and arbitrating over the case. An obvious lie that you can fall, slide, and have penetration take place. Whereas that is not the case here, we began by giving senators an indication of what they would be treated to by the deputy governor, an obvious lie. And we said that the deputy governor will come before you and look you straight in the eyes and lie to you. He has not disappointed. He looked you straight in the eye and gave very obvious lies that amount to insulting everyone's intelligence, with all due respect. Honorable members of the Senate, what then are you supposed to do with that kind of a witness? Who will come before you amidst the weight of evidence, amidst facts, and still take you through a lie and want you to believe them? And I started by saying that is the kind of witness that you should be angry at, that you should exercise anger at. You have that right. That moment, honorable senators, has come for you to tell the deputy governor that he had a duty to ensure that he speaks the truth. And even where he has difficulty speaking the truth, let that lie not be the kind that insults the intelligence of honorable senators. You had the opportunity to see the witnesses. You had the opportunity to hear the witnesses. You had the opportunity to analyze and question every statement from the witnesses. You can tell, honorable senators, that those witnesses were not credible, they were not truthful, they were not honest. How do you analyze a lie? You look at the presentation of facts and ask yourself, based on the conduct of the witness, based on logic, based on the way we all perceive things, does that make sense? When the deputy governor stands before you on oath, having lifted the Bible, and tells you, number one, that he does not know Dennis Misati. Yet, that is the son to his 32-year-old good friend. A friend that they have done each other favors, a friend that they have visited each other, mourned together, celebrated together, but he does not know Dennis. But he wants you to believe that somehow on 28th of May, Dennis, in the company of his father, visited him, and they sat at a distance and were not privy to the conversation. And that the only role Dennis performed that day was to pay a debt that his father owed him. Honorable senators, these are not 5-year-old children we are talking about, not 10-year-old children we are talking about. We are talking about married men with their families in the company of their father to visit the deputy governor. One of the sons that the deputy governor disowns as not having a personal relationship with. So then one would ask, what was the essence of the meeting? What was the essence of that visit? It must have been towards what Dennis was saying. It cannot be anything else. Honorable senators, when the deputy governor stands before you, a man of serious qualifications, serious titles, and he tells you that he's able to operate his mobile banking, that he's able to operate the M-Pesa app, but he does not know how to reverse money. That he received 100,000, rather, that he received money from Dennis, wrongly sent it to Lucy, but somehow does not understand the procedure of reversing that money. Is it that equivalent to the defense that was given by that gentleman? who forced himself on that girl. 2 days after that money was erroneously sent, the deputy governor has not visited any Safaricom shop. The deputy governor has not even talked to his aide because he's entitled to one. He has not talked to his personal secretary to assist him with a simple reversal. And he wants honorable senators representing the entire country to believe that lie. That is not a lie that you can afford to fall for. The deputy governor comes before you and tells you that, yes, I had spoken to Dennis' father for this employment favor, that, yes, I approached Lucy seeking for this favor, that, yes, I received money which he now terms as the payment of debt. And 30 minutes after receipt of that money, sends that money to Lucy by mistake. Now, logic dictates that the chain that is being talked about has not been broken. There is a clear trace of the intention of the money, the person who is supposed to procure that money, the person who is receiving that money first of all, and sending to that specific person. Why isn't it that these 100,000 could not be sent to a Jane, a random Joyce, just a random person? That would have been a lie that would have made sense. But to look you straight in the eyes and tell you that that money was not meant for that purpose, without debunking the entire chain, it's a lie. It's an insult to everyone's intelligence. His key witness, the father, to Dennis, again, is unable to explain why there was need to transfer money from his wife's account to Dennis and back to the deputy governor. And he tells you, he wants you to believe that he wanted to express love to the son by sending him money to go and withdraw, then hand it over to the deputy governor. I do not know how expressions of love are nowadays, but I do not think that senators are able to buy into that. That he gave the son the responsibility of withdrawing the money because the son was quick enough to go to Keombo Market, withdraw the money, and come back when he had a driver who can run that errand. But somehow he wants you to believe that the son would have walked or ran faster than his own driver. He operates an M-Pesa shop, he confirms, but does not tell you why that money could not be withdrawn from his own M-Pesa. Obvious lies. Lies that cannot be allowed to go on record. For that reason alone, then you need to tell the governor that he has breached the leadership and integrity code as we know it, that he cannot be trusted with leadership if he can look you straight in the eye, honorable members, and lie to you when you can tell clearly that it's a lie. I can go on and on with the lies, but you've had the benefit of listening to the lies. Do not allow your intelligence to be insulted. I will invite my learned friend, Mr. Mwangi, to take you through the evidence that was produced in this court, in this Senate, and how the County Assembly of Kisii has been able to prove all the 4 charges against the Deputy Governor. Thank you so much.
Honorable Speaker and members of the Senate, my name is Mwangi Ndegwa. I will be dealing with the evidence that has been produced. and also I'll also briefly touch on the obvious truths. Members of the Senate, the County Assembly has been able to produce before you trails and transactions indicating and showing how money exchanged hands from Joseph and Dennis to the Deputy Governor, and how the same money finally found its way to the Managing Director of Guasco for purposes of serving its purpose. Honorable members, it all began with obvious truths. Joseph Misiati approached the Deputy Governor, and the Deputy Governor has agreed to that and confirmed on oath. The Deputy Governor also confirms that he reached out to Lucy seeking for favors as had been sought from him by Joseph Misiati. And Lucy magnanimously told him that we shall only recruit on a meritocratic process. Honorable members, we have seen Dennis submitting before you and crying before you that he did sell his salon. Dennis produced a sale agreement for that sale. Dennis produced a sale agreement also for the sale of his household goods and equipment. And he said that he gave that money to the mother for purposes of safe custody. Obviously, there's a reason why the mother was not called as a witness, so that we are not able to debunk that theory that the money came from them. There is seen money being sent from Dennis at 8:33 p.m. on the 28th of May. The other transaction is at 8:37, a transaction of 150,000, and the last transaction of 49,000 at 8:43 p.m. on 28th of May. 40 minutes later, that money leaves the mobile phone of the Deputy Governor and goes to the mobile phone of one Lucy, the director of Guasco. Remember, honorable members, that Lucy received this money at 9:24 p.m. on the 28th of May, 2023. When Lucy received this money, she did not understand why the money was being sent to her. But the following morning, she made a call to the Deputy Governor, just a follow-up to confirm, why are you sending money to me? And in that conversation, and it's a conversation that the Deputy Governor has admitted that they indeed spoke, that indeed, while he was taking breakfast at his home, Lucy reached out to him. And according to Lucy, she states that the Deputy Governor said, this is as a follow-up to the requests I made to you for the assistance in the recruitment of my candidate, my preferred candidate. Now, honorable members, due to the integrity of one lady called Lucy, she asked the Deputy Governor to reverse the money. But obviously, the Deputy Governor does not reverse the money. What does he say? It's an error. And what does he also say? That the money was supposed to be sent to one Gladys, who is also a chief officer within the government of Kisii County government. And what we also see later, we also see that there was an intention, or there is a statement by one Gladys, who says in her statement that there was, the Deputy Governor's wife actually approached her for favors in regard to being given the tenders for supplying pharmaceutical products. And in her statement, she says that she was approached around the month of May 2023. And the same May 2023 is when the Deputy Governor gives or sends money of 100,000 shillings to also Gladys. So the question is, was the Deputy Governor sending money simultaneously, intentionally, for two intended purposes to bribe? Was he intending to bribe not only Lucy, but also intending to bribe Gladys? As I sum up, honorable members, the defense by the Deputy Governor should not be taken seriously. It is concocted. It has been summed up so as to rule this House not to vote for the motion. Members, I sum up by telling you that, or requesting you, to allow the motion on the basis of the grounds on the motion and the evidence produced by the County Assembly. I do invite my brother, Learned Senior Mr. Ndegwa Njiru.
Thank you, Honorable Senators. I must begin by thanking this House for spending quite considerable time. It tells me and convinces the whole country that this House takes its work seriously. If there are doubts out there that this is a House that is made of noble men and women, then that doubt has been eroded this evening for the last 2 days. And I therefore think it was then prudent for the drafters of our Constitution to think of creating a House of such high repute. A House that has been called upon to offer oversight over the performance of the county government. Had it not been for this House, I assure you, Honorable Senators, that the ordeals that the people of Kenya would have suffered out there would be enormous and untold for. It was then prudent and wise that the drafters of the Constitution gave the singular role of oversight to this House and told this House that your oversight will not only be limited to how the resources of the county must or will be spent. The oversight was granted unto you, members of the Senate, and extend to seeing to the effect that Article 10 has been implemented. That is a question of integrity. It calls upon you, Honorable Senators, to look at the conduct of the people working in the county assemblies. It calls upon you, Honorable Senators, to see to it that Chapter 6 of the Constitution has been implemented as it is. Chapter 6 of the Constitution presupposes a scenario of the Caesar's wife, that the people working in the county governments must be beyond reproach. They must not even be suspected of any scintilla element or any iota of misconduct. They should not be suspected that they even attempted to get bribed. This is not a case of an attempt. It is a case that evidence has been led to the conclusion of any reasonable member of the society that yes, Mr. Monda was found with his hands in the cookie jar. That doubt has been erased. When Mr. Monda was put to task, why didn't you reverse the 100,000 shillings that you sent to Lucy? He simply says, I fell asleep. At the county assembly, he indicated that he fell asleep. When he was taken to task and taken through his M-Pesa statements, even as late as 23:57 hours, he was still transacting. When he was put to task whether he understand the M-Pesa procedures and whether he saw the prompt messages, he simply feigned ignorance. I do not know how to operate an M-Pesa. Ignorance is no defense. Ignorance cannot discount his misconduct. Ignorance cannot let him be pardoned for defrauding the least members of the society. Honorable Senators, look at the person who was called upon to raise 800,000 shillings. A destitute youth, a jobless youth, a hopeless youth, a homeless youth, a youth whom we should be, instead of extorting, a youth whom Honorable Deputy Governor Monda should have been giving hope. Honorable Senators, the conduct of Honorable Deputy Governor of Kisii County does not breathe hope to the youths of this country. His conduct is a conduct that goes to telling our youths that unless you have a godfather in the status of Honorable Monda, do not attempt to apply for any jobs in this country. That is the message that the conduct of the Deputy Governor of Kisii County is sending out there. This government is spending a lot of time. The senators are on day-to-day allocating money to the counties to make sure that work and jobs are created. Those jobs are not created for the use of the status of the friends of Mr. Monda. The jobs are not created for the people who have connections with the deputy governor like that of Mr. Mosati. The jobs are created for all the youths. And behold, the Constitution provides that we are all equal before the law. We should be granted equal protection. But what is the deputy governor doing? The deputy governor is elevating through nepotism, cronyism, and favorism his friends. What of those youths? What of those, the Mama Mutura who spoke here? The Mama Mutura who passionately said, I have taken my child to school, and she has no connection to Honorable Governor Monda. What is the fate of that youth? Honorable Senators, you are being called upon to do one of the most solemn things, to tell any person out there who may think that he has the conduct and the ability of extorting youths like Honorable Monda, that you have no space in the Republic of Kenya. That is a message that must be sent clearly. And it is not just a message that is coming out of this house. It is also a biblical message. It is so biblical in the sense that in the book of Exodus, chapter 18, verse 21, we are being told, select capable men from all the people, all amongst yourself, men who fear God, trustworthy, and people who hate dishonest, and people who hate gains and appoint themselves as officials. This is a member who claims to be a church elder. He claims that he's a member of the SDA. Doesn't he know the dictates of the chapter that I have just read? Is this a person who should be trustworthy? Does he hate bribe? We answer no. Let it not be lost as I sum up that unless actions are taken as against these individuals, we shall water down the gains that we have made. Chapter 6 of the Constitution must be breathed. We must give life to that article. Finally, honorable members of the Senate, permit me to submit that the standard of proof of this case has been met. We were supposed to prove not beyond reasonable doubts. We were supposed to prove on balance of probability, and that standard has been met. I believe there is no doubt in any member of the Senate that Mr. Monda attempted to bribe Lucy. There is no doubt in any person seated before this house today that Mr. Monda sent the money to Lucy. And if there is any person with that doubt, may that doubt be spelled today. And what is the consequences of the actions of Honorable Monda? What is the consequences? The consequences is that his actions have put a family in collision. A father has gone against a son has gone against the father. A brother has gone against a brother. If Mr. Monda was diligent enough, if he's a person who is to be trusted, he should have chosen his path clearly and correctly. He would not have put the two families into collision. The collision that you have seen here and witnessed is courtesy of the misconduct of Honorable Deputy Governor of Kisii County. What is this other consequence? The other consequence is that the provisions of Article 26 have been compromised. That life begins at consent. A caution and a restraint will be made by any person who may think that child has nobody to fight for, that child that lost has no voice to speak for. It is you, the honorable senators, who are gonna speak on behalf of that child. It is you, honorable senators, who will speak on behalf of that unborn child. It is you who will say that justice will be heard. Subsequently, honorable members, as a consequence of these actions, an office has been compromised. The integrity of the office of the deputy governor has been eroded. The integrity of the office of the deputy governor has been put into disrepute. And for that reason, a vote ought to be taken and a vote ought to be cast to send the deputy governor home. Malcolm X in 1965 said, "If you do not stand for anything, you will fall for anything." That is the character and the conduct of Honorable Deputy Governor Monda. He stands for anything, and he falls for everything. He falls for bribery, he bribes Mama, he exhorts Mama Mutura, he exhorts people on bursary basis, he exhorts Dennis. If a Mama Mutura spoke that she was extorted, and we believed her, why should we not believe Dennis? Why should we not believe Dennis? When a question was put as to why the mother had to be involved in the sending of the money, the answer was, "I was doing financial management." I was doing financial management. I tell you, honorable senators, that the mother was brought in this case as a decoy. She has been brought here as a decoy to make sure that you do not see the correct network of this corruption and bribery. Let no one be invited that the money ever came from the mother. If it did came from the mother as earlier submitted, the mother would have been a witness to testify to that effect. Honorable senators, let it not be lost on us that on the 31st of December 2012, the Honorable Lady Deputy Chief Justice of this Republic committed a heinous offense similar to this one. And she was sent home on the count of pinching the nose of Rebecca. She was sent home on the count of asking Rebecca Kirubo that you should know people. Who are you? We give you power. We vote for you, then you extort us. We vote for you, then you steal from us. We vote for you, then you defraud us. How lucky are you? How lucky are you, Honorable Monda, that we shall vote for you, we give you our votes, and then you defraud us of our money? How lucky can you be, Honorable Monda? How lucky can you be? That is a question that must go and ring bells. Honorable senators, as I sum up, let us draw the lesson from the case of Nancy Baraza. If a Chief Justice was taken home on that one count of pinching the nose and arrogantly saying that you should know people, what of this person who has gained and benefited unjustly? What of him? You are told that 500,000 shillings was being paid as a debt. Has evidence been brought before this case, before this Senate, to prove that Mr. Mosati owed the governor at a particular point? Zero. No evidence. Let us rise to the occasion, honorable members. As I sum up, look at the Watergate case. The Watergate case was a tight case. Somebody breaks and organizes the breaking of the National Convention, the Democratic Convention offices. A president tries to conceal that, and that act of concealing sends President Nixon home. Today, it's not President Nixon. Today, it is not Nancy Baraza. Today, it's Honorable Monda. As I sum up, I am urging this Honorable House to do what is right, not what is popular, not what is easy, not what is enticing, but what is right. What is right is that which shall lead to giving the people of Kisii County justice. What is right is that action of upholding the provisions of the Constitution of Kenya. What is right is that of saying that the sovereignty of the people of Kenya must be respected. Finally, honorable members, for the loss of that child, and I insist, for the loss of that honorable child, Honorable Monda must go. For taking of the bribe from poor Kenyans, Honorable Monda must go. For failing to breathe confidence to the youth of this country, Honorable Monda must go. For failing to uphold the integrity of his office, Honorable Monda must go. For taking for granted this house, that he can blatantly lie to the house, Honorable Monda must go. For failing to bring and for lying before this house, Honorable Monda must go. I urge you, Honorable Senators, Honorable Monda must go. Much obliged. Finally, only one more issue, the competence of the motion. If the motion that has been brought before this assembly was not competent, Mr. Monda would not have lined up his witnesses. If it was not competent, he would not have appeared before the county assembly. The doctrine of acquiescence bides him from the beginning of the motion to the closure of sending him home. I'm most humbled.
Thank you. Now we shall move to hear the closing statement for and on behalf of the Deputy Governor.
Mr. Speaker, sir, members of the House, I rise to, in part, give part of the closing statement for the Deputy Governor. Mr. Speaker in the House, I'll reiterate the words of a member of this House who said during these debates that justice must not only be done, but must also be seen to be done. And to that I'll add that substantive justice must not only be done, but be seen to be done. And the reasons why I put this to this House as it goes to deliberate is that we have a situation where the DG has not had the opportunity to get substantive justice for a number of reasons. If the House is to consider the Hansard, the notice, and the motion that was before the County Assembly, it is clear what has been presented before you is a mutation of the case that was presented before the County Assembly. The case has morphed. And we look no further than the submissions by my colleague for the County Assembly, where he is now calling this Honorable House to impeach the Deputy Governor on the basis of alleged infanticide. These were not charges that were before the County Assembly. This was not even evidence adduced by Dennis Misati before the County Assembly. The issue of a miscarriage was never an issue raised anywhere before they came to this Honorable House. The morphing of this case is further evident from Lucy Waheto, their star witness. Before the County Assembly, and before the 8th of March. Her evidence was this money was received erroneously, we assume, from the deputy governor. They had a telephone conversation, and the deputy governor said nothing. He kept quiet. However, for reasons unknown, and that can only be inferred by this honorable House, following the impeachment proceedings, she has now changed her statement, imputed some malice to that money. A simple error in sending M-Pesa has taken new life. We leave it to the House to infer the reasons for the change of heart. We also note that the case before you has moved with regards to that most critical of issues. Who solicited this bribe? If you look at the motion as moved before the County Assembly, the case of Dennis Misati of the MCS Siochi, the Honorable Siochi, was that the DG learned of the job, went to Joseph Misati and solicited the 800 Kenya shillings bribe to get him that job. That case has morphed before this House, as considered by my colleagues in their submissions. They now indicate that Joseph was the one who told the DG about this opening. The morphing of the case is further evident from the videos that were presented before this court. The issues of bursaries and bribes that are linked to those bursaries, this was never before the County Assembly. This has been raised for the first time before this Honorable House. And the sum total of the foregoing is that for this House to uphold that hallowed maxim that justice must not only be done, but be seen to be done, we need to disregard the morphed case that is presented before you. And in so doing, you need to make an inference that there's a motive to the mutation. Following from this issue, there are some procedural lapses that were part of the proceedings before the County Assembly. You've been asked to turn a blind eye to these procedural issues, but we humbly submit to this Honorable House that substantive justice requires procedural certainty. The Deputy Governor had no procedural certainty in the process that was undertaken at the County Assembly. And this started on the 13th of February 2024 when a notice of a motion that was not supported by the evidence, was not supported by signatures, was moved and subsequently passed by the County Assembly. A clear nullity ab initio was allowed to move to the stage of a motion. And from that, on the 21st of February, the motion that is before, that has led us to this hallowed house, was moved and duly seconded. And as would be expected, this motion should have been put to the County Assembly to debate and make their determination. However, This is not what occurred. A motion to adjourn the proceedings was duly moved, not seconded, and I wish to underline that that motion was never seconded. But this notwithstanding, the motion was in unclear circumstances that one cannot decipher from the Hansard, determined, and adjournment duly issued. This adjournment, I wish the court to note, was contrary to the standing orders of that particular county government, which requires the motion to be moved and determined within 3 days. By the 24th of February 2024, that motion, having not by automatic operation of the law. We submit that from the 24th moving forward, there was nothing. The motion and everything that was voted upon on the 29th of February 2024 was nothingness. And from that, this Honorable House has been called to determine whether there's a valid impeachment. And we duly submit, given these grave lapses, that the motion and the impeachment as a whole was a house built on quicksand, foundationless, and this court must, as the big bad wolf did, blow that house down. Most obliged. I will now call my senior, Mr. Katwa Keegan, to conclude the submissions.
Mr. Speaker, sir, honorable senators, I would like to start my submissions by just highlighting the main issues that we would like you to take into account in making the determination as to whether or not you should come to the conclusion that a case of impeachment has been achieved. But our biggest emphasis, honorable senators, is that one, you maintain your mind on the question of whether a standard of proof has been achieved in these allegations against the deputy governor, and number two, that the burden of proving that indeed there were these breaches was on the county assembly. Correlated with that is that the case should not, your decision on whether or not to impeach should not be on a basis of what is newly introduced in the course of these proceedings, as my learned friend Mr. Michuki has said, being amongst others the allegations of infanticide. Now, going back to the substance of my submissions, I will elaborate on what I said when I was doing the opening address, that the entirety of this case is not founded on any document on the part of the accusers. There is no document, for instance, on the part of Dennis who says he bribed to show that indeed he had any money with which he could have given to the deputy governor to constitute a bribe from him to the deputy governor. There is no document from his brother to show that indeed the arrest was based on any other issue other than the dispute as to who was the owner of the trees. There is no document on the part of Lucy to suggest that indeed, other than the fact that money was sent by reason of an error, there is nothing to suggest that indeed that money was based on an understanding of corruption. And so, at the end of the day then, honorable senators, you will have to make a determination on this issue on the basis of who to believe. And the competition in terms of who to believe in this case would be his brother Robin versus Dr. Robert. It will be Mr. and Mrs. Misati, Mr. Misati being 68 years old, retired civil servant Judge Koa, versus his son who is 37 years old. Who do you choose to believe? And we already indicated to you that the wife of Mr. Misati swore an affidavit, which we are relying on, and we produced the M-Pesa paper trail. I am aware that my colleagues have said that the wife was maintained in this case as a decoy. And we are saying that cannot be true because we brought you the M-Pesa record. And the husband had testified on the issue being the background of how that money was raised and was remitted. So you would have to make a choice of who to believe between the son and the father. And in the event you have any doubt, it is our contention that considering the standard of proof that this Honorable Senate has adopted, as prescribed by both the Court of Appeal and the Supreme Court, the benefit of doubt should go to Dr. Monda. We would also pray that in considering this, you be careful that you do not end up with a situation where you allow a national Senate to be a forum for determination of family disputes. All the witnesses and the entirety of the case that the County Assembly has brought is founded and based on family. Now, I would like to digress at this point and just point out to you like this, that we have brought material with which we have contended that the reason why the Deputy Governor is standing trial is because of the issues he has raised to the Governor, and that the Governor then has initiated these proceedings for the Deputy Governor's impeachment. Now, we would pray very much that in the course of your consideration of this impeachment motion, that motive, that reason for having brought this case be a dominant factor in your minds. But more importantly, the decision having been made and determination having been arrived at that he must be subjected to impeachment, the fact that they were not able to find any case of either procurement, misappropriation of funds, and accountability of any other issue, the fact that the most that they could come with to you for impeachment, that the only thing they could come is through families, through his brother, through the son of Mr. Misati, to spoil the friendship, that is the only thing they could come up with. We submit, honorable senators, is an indication of just how impeccable the Deputy Governor is, that they couldn't get anything other than to go through families to initiate and engineer these impeachment proceedings. Now, before I come to the standard of proof, I would want to just invite your attention also to the fact that the main allegations before this Senate for impeachment being whether or not he received a bribe from Dennis, whether he gave a bribe to Lucy, whether he threatened Dennis, whether he misused the county staff, and whether he is culpable for having his brother arrested, are all issues that are in the hands of institutions and agencies that you as legislators, as lawmakers, have designated to take responsibility of investigating and determining. The three first counts being the question of whether he received a bribe from Dennis, whether he gave a bribe to Lucy, and whether he actually threatened Dennis, are all issues which the witnesses readily admit are in the hands of the Ethics and Anti-Corruption Commission. The issue of whether he improperly caused the arrest of his brother is an issue before the police. And the issue of whether or not there was misuse of the county staff, the witness came and said is in the hands of the county assembly. With that in mind then, we would like the question to occur to you as you entertain the question of whether or not to impeach, as to whether you will choose to intercept a process of investigation by EACC, by the police, and by the Kisii County Assembly. You will intercept that process, take over the process, and make a decision on it. Or you would rather wait for the determination of the cases before those agencies, which you yourselves as legislators have already determined should make those decisions. Now, my colleagues for the County Assembly have relied on 2 cases, and those 2 cases are of very doubtful basis. The first one is the very repeated story of one Nancy Parasa having pinched somebody's nose. That's one thing they're relying on to persuade you that you should impeach the deputy governor. The other one they're relying on is the repeated reference to Watergate. Now, honorable senators, we would like on our part to bring you nearer home on what you yourselves have said, and in terms of your standard of proof for purposes of determining impeachment. And the first point, the first threshold is the provisions of Article 181 of the Constitution. Article 181 of the Constitution, 1A and C require that before you come to the conclusion that there is reason to impeach a deputy governor or rather a governor, you need to be satisfied that indeed there is cross violation. And our question then to you would be, on all the 5 counts, on the allegation of a bribe from Dennis, giving a bribe to Lucy Waito, the allegation, the alleged threat to Dennis, the alleged misuse of county staff, the alleged arrest of the brother. Do you come to the conclusion that indeed there is cross violation? The other criteria is found at Article 181, 1B, being that there is a serious reason to believe that a crime has been committed. And we submit, honorable members, that based on the analysis of facts that my colleague who came before me has made of the facts, and which I will look at again briefly in a short moment, we submit that there is no manifestation of any gross violation of the law, and there is no serious reason to believe there is any crime that was committed. And further, in applying that criteria, when you are considering the question of whether or not to impeach the Honorable Governor, His Excellency Honorable Iria, you, through your special committee, you said that in the event an issue is in the hands of an investigative agency, then that investigative agency should be allowed to conclude their proceedings. And in that case, you said the EACC and the Public Procurement and Oversight Authority should be given room to conclude the process. And if they come to a conclusion that there is indeed any wrongdoing, then they can come back to the Senate through the County Assembly. And we are requesting that you apply the same standard, that having pointed the witnesses of the prosecution, and I'm saying prosecution in this case being the County Assembly, having come and readily told you these issues are in the police hands, these issues are in the hands of EACC, these issues are being investigated by the County Assembly functions. Having said that, it brings you irresistibly to the need of maintaining the same position you took in Iria case, being that this is a case that in fairness should be left to those agencies to conclude, as you did in that case, and that you apply the same standard as you did, you apply the same standard in the case of Dr. Monda as you did in the case of Honorable Iria. The same position was taken in the case of Professor Chepkwony, Kericho County Governor, where you said before you as a Senate can step in, you need to satisfy yourself that all other oversight agencies and mechanisms have been exhausted, and that it is not proper that the Senate is the default option every time somebody feels like there is a fight between a brother and brother over trees, there is a fight about whether or not there is an abortion. There is a fight as to whether or not there was an error in pressing a letter G as opposed to letter H in the case of the Lucy. And so we are saying, honorable members, the same way you decline to entertain the case of Professor Chepkony, please decline to entertain the case of Dr. Monda, to the extent to which the other agencies that exercise oversight have not been exhausted and they are not a default option. We also rely on the determination made after this Senate had had the case, in the case of Songo, which was determined, Honorable Songo, which was determined at the Supreme Court, that when considering the question of whether or not there is an excess warranting the need for impeachment, the evidence should be credible and there should be evidence of extraordinary wrongdoing. And I just want to put a lot of premium on the use of the word extraordinary wrongdoing. And we submit, honorable senators, that in the case of Dr. Monda, when you are told that there was a bribe given to Dennis by, that Dennis gave the governor a bribe, when you're told that, and then Dr. Monda comes to you and tells you, number one, the money did not belong to Dennis, it belonged to his parents. Number two, Dennis did not participate in the discussions about that money. He has no idea what was discussed before the money was sent. When you're given that kind of evidence, where, in fairness, with what reasonable measure would you say there is extraordinary wrongdoing to be found in the conduct of Dr. Monda? When the father of Dennis is saying, it was my money, I was refunding a debt, a loan, some money I had taken earlier on, a loan that I had taken earlier on. We are asking, where is the extraordinary wrongdoing? Where is the gross violation? Where is the serious crime in the issue of the 100,000 to Lucy Wahito? It is a fact that indeed money went to the M-Pesa of Lucy Wahito. But we pray that you juxtapose that point with number one, the point we've made that it was an error. Now, I am aware from the questions that you asked Dr. Monda in the course of his evidence as to the question of whether he has M-Pesa app, why he slept without seeing who the money had gone to, and so on and so forth. But all that said and done, if I were Mr. Ndegwa, I would refer you to the Bible and say, throw the first stone if indeed you can say none of you who has a vote in this Senate has never made a mistake to send money to a wrong person. And we pray that to the extent, I would want to imagine that 100% of you have done. But even if it's not 100%, I'm sure most of you have done. Please do not throw a stone in the direction of Dr. Monda merely because he made a mistake that any of you could have done and is, or is otherwise likely to do. And for those people who are skeptical about whether or not the mistake was there, we pray that number one, where you have doubt, that doubt should be exercised to the benefit of Dr. Monda. On the allegation of threats to Dennis, Dennis says that the threats were communicated to him through his father. His father comes and says, I have never been told anything that constitutes or amounts to a threat to Dennis. And so, with that kind of a situation where Dennis readily admits that I never spoke with Dr. Monda, and says that threat was communicated through the father, and the father says there was no such threat. Where do you find cross violation? Where do you find serious basis to assume that a crime has been committed? Where do you find a basis to say there was an extraordinary wrong committed as was determined in the case of His Excellency Honorable Songo? On the issue of the county staff, we are all, the witness came and readily considered that the deployment of the staff is not exercised by the deputy governor. The staff are assigned to him. He doesn't have a say on who is to be sent there. Now, if, as that witness said, it were to turn out that the wrong type of staff was sent there, that there are enforcement officers who are sent to cook and were to cook for dogs, as Mr. Ndegwa said, if that were to be the case, whose mistake is it? Are you going to impeach Dr. Monda for having been sent enforcement officers to go to the kitchen, or are you going to ask that the county enforcement officer and the Public Service Commission do account for that? We pray that you do find that that point as to whether or not the right staff were there cannot be pegged on the head and on the shoulders of Dr. Monda. Now, the issue of the 20 enforcement staff, you saw clips there were attempts to play clips and so on and so forth. Nowhere did you see the 20 staff, the 20 enforcement officers going to effect arrest on Ropen, the brother of Dr. Monda. There's nowhere where there's any evidence of 20 people going there. But assuming, even for argument's sake, that that was the case, I would pray and plead to persuade you, honorable senators, that the real question here is whether or not Robin and Robert had a dispute over trees. And that is cast in stone. It is an absolute fact that indeed the two of them had a dispute over trees, and the witness who brought this complaint came here and said that. Number two, it is an absolute fact that the report was taken to the police. Three, it is an absolute fact that it is the police who effected the arrest and took Ruben to the police station. He was not taken to the cells belonging to Kisii County, where then you would come and draw a conclusion that probably the enforcement officers were in charge of that process of the arrest. With all those grounds, if you were to be inclined or to be tempted to deem a wrongdoing to have obtained, shouldn't the OCS of the relevant police station have been summoned instead of having summoned Mr. Hagai? Shouldn't that have been the person to be summoned to come and say whether indeed there were 20 enforcement officers and whether there was a basis for the need to arrest the brother? We pray that you do find that on the premises of that issue, there is no manifestation. There is no manifestation of cross violation. There is no reason to deem that a crime was committed, and there is nothing extraordinary that there is nothing negatively extraordinary that Dr. Monda did to warrant the need for him to be subjected to impeachment. Lastly, on that issue of the enforcement officers, the witness, Mr. Agai, came here and produced 3 letters. All the 3 letters are very consistent in what they say. They all say that the sub-county enforcement officer is the one who went with those officers. So assuming those people went, and we are saying there's no evidence that they went, even assuming they went there, there's nowhere where the hand of the deputy governor can be said to have existed in the deployment of those officers. For those reasons, then, honorable senators and Mr. Speaker, sir, we pray that you come to the conclusion that indeed, on the allegations brought against Dr. Monda, there is no evidence of gross misconduct, there is no evidence of him having committed any serious crime, and there is no evidence of him having abused his office or having done anything extraordinary to warrant the need to hold him liable for impeachment. I would like to cover a few of the other grounds that my colleagues have raised in their submissions. One is the issue of bursaries. Now, several times in the course of our presentation of our evidence, we kept being told, what is the relevance of the issue of the change of the budget from the original budget passed by the Assembly to the budget that was submitted to the Controller of Budget? What is the relevance of, where is the basis of the allegation that, or rather the point that the governor has migrated from the official offices to his home, and so on and so forth. We pray that as you reflect on this case also, the question occurs to you, what is the relevance of making the allegation that Dr. Monda is responsible for the infanticide? That has not been proven. So the case of the county assembly is, okay, we may not have proved that there was any bribe given to Dr. Monda by Dennis. We may not have proved that Lucy Waito received the money as a bribe. We may not have proved that Dennis was threatened. We may not have proved that the county staff were misused. We may not have proved that the brother was properly arrested. We may not have proved that. But please, even if you come to that conclusion, move on then and impeach him on the other grounds. One being that he's responsible for infanticide, and my colleague in his usual eloquence makes reference to blood, the cry of a baby, and all that. Where is that case? Was any case brought before the county assembly about any baby who was killed by Dr. Monda? And if there was none, we pray that the emotions that the attempt to whip up emotions amongst yourselves should be rejected. There was an attempt also to use videos to say, oh, there's somebody who sells mutura, or there's somebody who bribed, was asked for 20 million to get a bursary of 3,000, and so on and so forth. Now, I would like to address the two issues that arise from there, video and the question of bursaries. The county assembly came and said, we did public participation. The public participation report is here. It is at page 21 to 54 of the county assembly report record. The entirety of that report does not make reference to any video anywhere. And we would want to be as respectful as possible, both the county assembly and most especially, much as they probably, we would like to be respectful to them, even if it were to be the case that they do not deserve it. But we would really like to be very respectful to you. And so when we say that the videos are fabrication, we say that with a lot of caution. We are saying that after thinking about it seriously. We say that because it is inevitable for us to tell you that indeed those videos, which a number of the senators said the Mama Mutura and a couple of others touched them. We are telling you, please, when you look at it with circumspection, with reference to the fact that it is not in the public participation report. If it was there, what was difficult about it being incorporated there? Number two, if it was there, where is the background of public participation? We pray that you reject those videos, you reject the emotion that those videos were meant to whip up. On the bursaries, when the witnesses were cross-examined, they came to a point, both especially Honorable Sioja, Honorable Karen Magara, and the other witnesses readily said that the issues of bursaries are domiciled in the office of the governor, and that there is a committee that deals with those bursaries. So at what point would you as senators be being asked to deem Dr. Monda to be involved in bursaries when the witnesses for the county assembly are contradicting their own witnesses through those videos, saying that bursaries have nothing to do with the deputy governor? We pray that the issues around the videos and the bursaries do apply to every aspect of this case, being that there is a lot of manipulation of testimony, fabrication of testimony, and an attempt to mislead this Senate. Lastly, on that issue of bursaries and video, I pray to remind you that indeed those issues do not come back at the Assembly, and you remain faithful to the intention of the law, that for you to entertain and determine whether or not to impeach a governor or a deputy governor, it has to escalate from the county assembly. And the sense of escalating from the county assembly is that both the case, the evidence, and the issues should remain the same at the county assembly and at this Senate. And that therefore, the issue of bursary not having been there, the videos not having been there at the county assembly, they are not eligible for your consideration. My colleagues for the county assembly have also introduced another issue that was not in the county assembly. The issue of Gladys Aminga. Gladys Aminga was not a witness, and in her statement that we saw today, she says that having listened to what went on at the county assembly, being a process of filling up gaps that we challenged at the county assembly, I have come to explain this and this. And she says that there's somebody by the name Bernard who was given a tender. That Bernard is a cousin of Dr. Monda and his wife Joyce. And when Dr. Monda was asked, he says, I don't know that Bernard. And so the question is, to what extent would the county assembly go to fabricate evidence and to assign relatives so as to demonstrate an alleged case of manipulation of procurement? One. Number two, my colleagues in the course of cross-examination of Dr. Monda asked him to confirm that indeed he forced Gladys Aminga to award a tender to the said Bernard. And when Dr. Monda insisted on being shown where that alleged force was there, they abandoned that line. And the point we want to make is the face of that statement does not suggest anywhere that Dr. Monda was involved in any tender awards to Bernard, a person he doesn't know, or any payments or the company is involved in. And the arguments by the county assembly reflect how disparate they are, that when they cannot demonstrate the issue of the alleged receipt of a bribe from Dennis Misati, when they cannot demonstrate that Lucy Waito was bribed, when they cannot demonstrate that Dennis was threatened, when they cannot demonstrate that county staff were misused, when they cannot show that the brother was irregularly arrested, when they cannot prove any of that, they say, okay, let's move on. Look at this Aminga. Don't you see that this Aminga is a relative, that this Aminga gave a tender to Bernard, that Bernard has two companies, that these two companies and Bernard are related to Dr. Monda? We pray that you reject the totality of that on the two grounds. One, that the testimony of that Aminga on the face of it does not support what they were trying to say, and number two, was not part of the case that was there at the county assembly. Arguments were made also about the 100,000 that was sent to Gladys Aminga. Gladys Aminga readily said that as a witness of the county assembly, I received 100,000. And in our affidavit, we have said in addition to 100,000, he received another 40,000 and received another 65,000. Gladys Aminga, who is part of the county assembly case, readily said, yes, I received the money, and has assigned and ascribed a reason to the receipt of that money. And what is the reason? Supply of ballast and other construction items and transport services. And so we would pray that even as you reflect on that issue, Dr. Monda cannot be subjected to a process of impeachment on the issue around Gladys Aminga, when Gladys Aminga himself has bailed out the case of the county assembly. She has said, it is true, I received the money, and the value for this is this, and it is not available to you, Honorable Senators, I submit, for you to go behind the word of Gladys Aminga and start entertaining the arguments made by the advocates for the county assembly, who should actually be defending that Gladys Aminga. Now, I would like to just say a few things then on the issue of the technical issues that we raised. The county assembly witnesses, especially the mover of the motion, Honorable Sioja, readily agrees that the motion was prosecuted out of time and public participation was conducted out of time. That he readily accepts. And he says it is indeed contrary to the provisions of Standing Order 60 to 64 of the Standing Order for County Assembly, Kisii County Assembly. He said he attached particulars to the notice that he moved on 13th of February 2024. And when asked, he says, yes, I can see the notice doesn't have particulars, but indeed those particulars were given. And so the question is, what happened to those particulars? So, but the bottom line is this, the notice that was moved on 13th, as you look at it today, did not have details and particulars. The motion was not moved under the provisions of Section 15 of County Government Act and the standing orders of Kisii County Assembly, standing orders number 197 and 198. With all those considerations, my colleagues have told you that please, when you go into those technical issues, treat the technical issues as non-issue because the defense, Dr. Monda's defense, have acquiesced by bringing witnesses. And so I would want to ask the question then, what were we supposed to do? Were we supposed to just come and smile and not do anything? One. Number two, we raised those issues at the start of these proceedings, and the ruling asked us that the issues you are alleging, the question of whether or not it was on time, whether or not it had particulars, whether or not it was moved properly, are issues that we'll have to determine after listening to the facts. And so we are saying that by presenting witnesses, we were not acquiescing nor abandoning our preliminary issues. We were doing what the ruling of this Senate said, being that demonstrate the basis of those technical arguments through the facts that you will adduce. And we have demonstrated that spectacularly through both cross-examination of the witnesses of the county assembly and through our own witnesses confirming that each of those wrongdoings happened. Now, I am aware that a number of senators have said that we should, based on the provisions of Article 152 of the Constitution, 159 of the Constitution, we do not want to look at the technicalities. And then on our part for the Deputy Governor, then we would want to ask you, what was the purpose then of the rules? Why are we sitting, why did we sit yesterday up to midnight? Why are you sitting past hours today? Isn't it because the law prescribes that some things are to be done within time? Isn't it because you are being faithful to timelines? And if you, at this national level as senators, are prepared to go out of your way and comply with the law, why should you give latitude to county assemblies to say, we will smilingly disobey the timelines that have been set and it shouldn't matter? Why should you extend that latitude? And most especially when those county assemblies do not come and say, oh, sorry, we were out of time because there was an earthquake. They are not saying we are out of time because there was COVID outbreak. They are not giving any reason or any excuse for why they are out of time. We pray that for purposes of standardization of the rights of the parties, for purposes of the rule of law, you do insist that unless there is a good reason why you should invoke the provisions of Article 159 and entertain issues and say it is a technicality. Before you do that, a justification needs to have obtained, and that justification and the law allows for that extension. We submit that the law does not allow anywhere for that extension of time. And therefore, we pray that you do reject the motions for lacking particulars, for mutating from the date of 13th when the notice was issued, and mutating into something different by the time it was being moved on the 21st as a different motion, and for not having been moved properly. We pray that you do be faithful to the law that is keeping you seated here today up to this time and yesterday also. You do enforce that law and say that motion is null and void to that extent. Now, I am aware that the probability is that the county assemblies have been casual about it. I would pray that the Senate, in developing jurisprudence, do not encourage that feeling that it doesn't matter. All we need is to just throw anything in the face of the Senate, and the Senate will readily entertain it. that you do say everybody must follow the law, and that otherwise the rights of parties, including Dr. Monda, will stand violated. I would like then at this point to cede the few remaining minutes to my colleague, Mr. Ochoki. But before I do that, I would just like to cover one other issue on the issue of public participation. I've already pointed out to you that the public participation was not signed. The public participation was done out of time. It was done on 26, which was 3 days after the close of the period within which those things were, within which the impeachment was to have been concluded by 23rd, and that clearly, and this is very important for us, the public participation was not funded. They just said, let's go for public participation. Now, without funding, you have a situation, as we demonstrated through evidence, that the governor then took charge of it, which is a different arm of the county assembly. He funded the process. Not only funded in terms of cash, he also funded it in terms of personnel. And we pointed out to you instances where the ward administrators were the ones collecting the fees. We want to pray that you do find that and serious. Actually, we would want to pray that you apply the criteria of Article 181 of the Constitution, being that that kind of conduct was a gross violation of the Constitution, a gross misconduct, evidence of serious crime, and an extraordinary excess on the part of the governor and the executive. With that, then I would pray, sorry, one last thing before I hand over. Arguments have been made about Lucy Waito having been bribed. Now, collateral to our explanation that indeed it was an error to have sent this money to Lucy Waito, we pray that you keep in your minds these other collateral circumstances. Number one, Lucy, in a statement of 8th of February, says the interviews were done on 15th of May 2023, and says this money came to me on 28th of May, which is approximately 13 days down the line. Now, she also readily says that the interviews that were done, whichever date it was done, according to her, she wanted to change the date from 15th to 25th. But our position is that it was on 25th, but whichever way you look at it, whether it was 15th or 25th, the position still remains that by the time she is receiving the money, the interviews have been done, scoring has been done, and the scoring has been done by people other than her. And she says, if you want to succeed in those interviews, assuming anybody really was determined to succeed in those interviews by crook or whatever means, you would need to go to those people who are scoring. She does not say that when, in her allegation, she does not say that Dr. Monda told me to go and influence the board members. So if you were to say that there was any intention of influencing the interviews, wouldn't it be necessary then to ascribe intelligence to the mind of Dr. Monda? And in ascribing that intelligence to him, to say that if he was really interested in compromising the process of getting this job for Dennis, he would go to the board members who are answerable to him, because those people are appointed by the office of the governor, where he serves as the deputy. So we pray that you keep in mind those two things. One, by the time this money is coming, scoring has been done, and the winner or the successful candidate is already a closed issue. Number two, if it was intended to bribe and get this job for Dennis, the people that needed to have been approached are the people who are scoring, and it is a fact that there is no allegation of those people having been approached. And for those reasons then, I pray, honorable senators, that you do find that the threshold has not been achieved in this case of Dr. Monda. One. Number two, that this Senate cannot be a platform of any default case of a pen being lost, they come here to say impeach him. Whatever small thing, including family disputes, that this Honorable Senate is not a forum for that kind of resolving family disputes. Number three, that you do find that to the extent to which these cases are in the hands of constitutionally mandated agencies, being EACC, the police, and the county assembly, you should cede ground for those institutions to conclude their process. And lastly, that considering that this is a question of one word against the other, you do find that our witnesses are credible, are superior in the quality of their testimony, as opposed to the witnesses who the county assembly called in the disparate attempt to achieve the removal of the deputy governor. With that, Mr. Speaker, sir, and within our time, I would request that my colleague, Mr. Ochoki, comes to close our submissions. Thank you very much, honorable senators, and Mr. Speaker, sir.
Honorable Speaker, sir, and senators, allow me very, very briefly just address the facts that my colleagues very emotionally wanted you to believe. A church elder has been called a culprit and a liar in this honorable house. But if you are to look at the evidence in totality, honorable senators, you are being told to send the honorable deputy governor home when he never spoke at any given time to the complainant, the gentleman that is now famously known as Dennis. Dennis told his house that all information about the bribe that you are being told the DG took were told to him by his father. His father was here. He came here and swore and told you there was no bribe. Dennis told you that 300,000 shillings was given to the deputy governor by him and his father. His father was here. He told you there was nothing like that. He told you that the 251,000 that his father sent to the deputy governor was a bribe. His father was here and he told you that wasn't a bribe. The senators have asked the witnesses about timelines from when the deputy governor received the M-Pesa message to when he sent it to Lucy Wahito. You have not asked the question, honorable senators, after how long upon receipt of those funds did Dennis send them to the DG? That gives credence to his father's position that that was instructions, that money was supposed to, he was supposed to go and collect cash, but because the shops were closed or the M-Pesa outlets were closed, then he could really do nothing. You have been told about a bribe to Lucy Wahito, and a lot has been said about the 100,000 shillings. Honorable senators, look at the statement of the deputy governor. Shortly after the alleged conversation with Lucy Wahito, he sent Gladys Aminga the 100,000. Then his version, purely because of the 100,000 shillings that was sent to Gladys Aminga, is believable. He is not a liar. You have further, honorable senators, been told that that money that was sent to Lucy Wahito was a mistake. All of us make a mistake. I'm not as old as the honorable DG, but I have sent money to wrong numbers. Very shortly, and honorable senators, you have been told about enforcement officers, abuse of office. Even the head of enforcement was in this house. There was no mention of a single name of an enforcement officer that did the acts that you are being told were part of the abuse of office. Further, honorable senators, when you sit to make a determination, there was, you saw the drama. And when we started, we told you, you will see the kind of preparations, the fiction that the other side had prepared. You saw people cry here. It's just sad that old people, the brother to the DG, can come and tell you that a police station is 2 kilometers away from his home. He has not made a report to that police station. He has traveled 500 kilometers to the Senate. He's telling you, send his brother home. That is akin to that old lady or the lady in the Bible who was saying, cut the child into two. The Senate is being told, cut the child into two. Send the senator home. You cannot send the senator home, honorable senators, when the evidence of a father who loves his son is being said that do not believe the evidence of a father who loves his son, wishes his son the best, and who's come here and told you that there was nothing like that. So all those charges that have been brought against the deputy governor are nothing more, and as my brothers have submitted, they do not meet the threshold. In as much as my brother was telling you, send the governor home, let the governor go back to Kisii and serve his people. He was elected, and the job of the Senate is to check out. And my brother has told you and submitted that clearly there is nothing. If you are to send the deputy governor of Kisii home, based on the evidence that have been presented to this house today, you will do a lot of injustice, honorable senators, to the people of Kisii. Let the governor stay, let him go and serve his people. That is our plea, and we hope that you will not believe, and there will be no stain in the name of this great public service servant who has served this great country in very many different capacities. Thank you very much, honorable senators. We pray.
Thank you to both the teams, that is the team from the County Assembly and the team formed on behalf of the Deputy Governor. Now, pursuant to Rule 27 of the Rules of Procedure, as contained in the third schedule to the Senate Standing Orders, the Senate shall now proceed to a camera session to deliberate on the matters that have been raised before making a decision. The camera session shall last for 15 minutes. Thereafter, we shall reconvene plenary, where then the Senate will be called upon to make a decision on the matters that have been raised. At this juncture, therefore, I will ask the parties to withdraw from the chamber. Members of the public, those seated in the speaker's gallery or in the public gallery, to also withdraw from the chamber, and live broadcast to cease forthwith.
Can we proceed that way?
Thank you, Mr. Speaker.
And council, take him slowly.
I will.